Good morning. My name's Mary Lawrence from Osborne Clarke, and I head up the Health and Safety team, and I'm joined today by my colleague Alexandra Gower, who's an Associate Director in our construction team. And we're here this morning to talk to you about the construction design and management regulations and how they're changing in 2015. This webinar is going to last just under an hour, and if you turn to the first slide, you will see what we are going to be covering in today's session. So first of all, we're going to be talking about the background to the new regulations. We're going to be looking a little bit about what they're all about and where they've come from. Key changes for those of you familiar with CDM 2007, between those and today's regulations. The different roles that people play within the CDM environment, and some of the more specific requirements of the regs, including competency, paperwork, notification, how this is going to affect domestic client arrangements, transition, and then looking at a couple of case examples to help you think about how these might be applying to your business, and importantly, what is going to happen next. So, first, if you turn to the background to CDM 2015, a little bit of background about where these regulations have come from to help you think about why they might be relevant to your business. So for those of you who know anything about the 2007 regs, 2015 is going to be the third incarnation of these regulations. They all started in the early 90s following a EU directive in 1992. And the first set of UK regulations were introduced in 1994. Following some consultation which lasted a period of 2 years, these regulations were then changed in 2007, and that's what we are currently working from, if you are listening to this webinar pre the 6th of April. And the CDM 2015 regulations are due to come into force on Monday the 6th of April 2015. So I think before we start looking at what the 2015 regulations say, what we really need to understand is why are they being introduced? Well, the EU directive related to minimum safety and health standards on temporary and mobile construction sites and the running of construction projects. And that, as you will see when we turn to the next slide, in terms of the definition of construction, is defined very broadly. In the UK, many of you may be aware that there has been a real focus on construction safety by both the Health and Safety Executive and indeed by government over the last decade or so. Why is this? Well, there were reports in 2000 and as recently as 2009 which have identified that there is still an unacceptable number of construction deaths and indeed injuries in the UK. And the overarching aim that we think is particularly important to keep focusing on when looking at how these regulations apply to your business and what you're going to do with them, the overarching aim of these regulations is to focus on safety in construction projects right at the very outset of a project. So next slide. Why have we had 3 sets of regulations since 1994? Well, broadly speaking, there has been criticism of both the 1994 and indeed the 2007 regulations for bureaucracy and ineffectiveness in achieving this end goal of safety improvements in the construction sector. The regulations have been very much misinterpreted over the years, and instead of reaching those goals of improving safety, it has been seen by many that they have led to tick box exercises in the industry. The idea of coordination in pre-construction and design phases simply hasn't been well embedded, and the 2015 regulations, as you will see, are really focusing on those areas. Separately, there is a need for the regulations in 2015 because of there being actual problems with proper implementation of the 1992 EU directive. That hasn't, we are told, been properly incorporated into the UK. And the key areas which the 2015 regs are seeking to rectify are firstly that the regulations must now apply to all construction projects, and that includes domestic client situations. And the other area of significant change which we're going to talk about throughout this webinar is what is the trigger for formal appointments and paperwork. Previously, for those of you familiar with 2007, the trigger was all about whether or not your project was notifiable to the HSE, and that meant that it was the more complicated or larger projects generally who required the formal appointments and paperwork. That is now being changed, and it's been seen that the EU directive actually required application to all projects where there was more than one contractor involved. So next slide, what is CDM 2015 all about? Well, as I've just touched upon, the changes in 2015 are aimed at the following. Firstly, a simplification of roles and duties under the regulation. Secondly, a front-end focus on safety in projects, and that is pre-construction and indeed pre-design stages. And thirdly, a shifting of responsibility onto a CDM client who is seen to have the most power to require change on a project. And as you'll see as we go through the regulations, the changes are likely to require formal appointments and duties on a number of projects which had previously avoided them. Who's going to be affected most by these changes? Well, we see the people to be most affected to be anyone who is fulfilling a client role in a project, also anyone who is seeking to take on the principal designer role, in particular designers who are looking to fulfill that role who may not have previously undertaken CDM coordinator roles under the 2007 regs. And finally, a large impact on smaller contractors, particularly those working on domestic client projects who were previously unaffected. So the next slide looks at the starting point when deciding whether or not your business is affected by CDM 2015. And I suggest that when looking at these regulations and the impact they're going to have on your business, the starting point is, firstly, is the work that we're involved in or about to be involved in likely to be defined as construction? We're going to come to the definition of construction on the next slide. But assuming that you've met that, then what is going to happen is CDM and the spirit of it is most certainly going to apply to your work. You are then, of course, going to turn to whether any of the additional requirements of the regulations in terms of appointments and paperwork apply. And firstly, what you might need to define that is to look at what you are considering to be, quote-unquote, the project, and we're going to come on to that. Having identified your project, the second core question is there going to be more than one contractor involved on the project? And we're going to be touching upon this later on, but principally that is not going to be so simple as a question to say, have I got a contract with one organisation, therefore only one contractor? You're actually likely as a CDM client now to be needing to be looking a little bit more. For example, if that one organisation subcontracts out work or uses self-employed workers, there is likely to be deemed under CDM 2015 to be more than one contractor. Now, if you have determined that yes, the works are construction works and yes, there is more than one contractor, then as a CDM client, you are going to have to be making formal appointments of principal designer and principal contractor, along with requiring additional paperwork to normal construction projects of a health and safety file, and we'll talk about that in due course. Now, for those of you familiar with the 2007 regulations, this is a really big change. The question is no longer, is the project notifiable? It is, do I have more than one contractor? And that's going to mean a lot more projects are going to be caught. Next slide, I said I was going to turn to what the definition of construction is. On the slide in front of you it is the wording from the 2015 regulations. Now, this wording is almost identical to the 2007 regulations, but it's one that's very useful to come back to, even if you were very familiar with those. And what you will see detailed on there is that there are a very large number of works which will be counted as construction, and traditionally you may not have always considered those works to be construction. If you turn to the next slide, you will see that essentially what that definition says is that if you are building anything, refurbishing or altering any building or structure, carrying out fit-out work, maintenance, which includes cleaning, excavation or site clearance, putting together or taking down structures, demolition or waste disposal, or any form of installation work, then you are likely to be counted as undertaking construction. Looking next at the key changes from CDM 2007, we will cover each of these changes in more detail shortly, but as a summary, the key changes are the change in the roles and the appointment and the focus on client responsibility in relation to appointment of a principal designer role. The appointments need to be made much earlier in the planning phase than was previously the case. There's been a change in the approach to competency with the removal of some specific requirements. The paperwork requirements have changed. Primarily, they need to be prepared much earlier for construction work. And we did mention about domestic clients and the fact that now the smallest of projects will fall under CDM 2015. The threshold for notification to the HSE is one of the things that's actually increased under CDM 2015. Looking next on the next slide at the new CDM client role, there has been a general shift with responsibility onto the client under CDM 2015. We've already touched on the definitions of both project and construction phase, but the client is the person who is at the top of the chain and for whom a project is being carried out. The appointments that the client needs to consider will be those such as principal designer and principal contractor, and it's important to note that those appointments need to be made in writing. To compare the client roles under 2007 to 2015 regulations, we've put in on the slide in front of you this table of summarising those key changes. So firstly, the client's role under 2015 is to make suitable arrangements for managing a project. That compares to having to take reasonable steps to check that there was suitable management under the 2007 regulations. The arrangements that the client needs to make must be proportionate to the size of the project and the risks involved with that project. The client should be considering whether it would be appropriate to prepare a brief to notify all members of the team of the proposed project and its intentions. And at this stage, the client also needs to begin assembling the project team. The next key obligation is that the client must provide the pre-construction information. Previously, the obligation was to ensure that the pre-construction information was provided promptly. We'll touch on pre-construction information a bit later, but it's information which is in the client's possession or reasonable for them to obtain. Again, the information needs to be relevant, appropriate and proportionate to the nature of the project. The next obligation is the key appointments that the client must make. The client must appoint the principal designer as soon as reasonably practicable and before the construction phase starts. That compares to the 2007 obligation, which was to appoint the CDM coordinator as soon as practicable after the initial design work had been done. Now the focus really is on the client making sure those appointments are put in place as early as possible. The client also has to ensure that the construction phase plan is drawn up by the principal contractor, ensure that the principal designer prepares the health and safety file, and finally the client must be the one to notify the HSE of the project. It is possible for the client to ask a third party to do this on its behalf, but if the third party doesn't do so, it is the client that's left with the responsibility of making sure this is done. So any liability attaching to failure to notify will remain with the client. And the client must also ensure that the
a notification to the HSE is updated as and when necessary to do so.
So turning then to the principal designer role, this in our view is the biggest change under the 2015 regulations. And for those of you working under the 2007 regulations previously, and perhaps very closely with CDM coordinators, may have heard them say to you ahead of the 6th of April, and this is essentially a change in name only under the new regs, and a principal designer is simply a CDM coordinator under a new name. Now this is something that we fundamentally disagree with, and we're going to talk you through why. The key to look at when thinking about whether a principal designer needs to be appointed is looking at what the principal designer needs to be able to do under the 2015 regulations. And under those regulations, they indicate that a principal designer needs to be appointed as soon as possible before design work starts, and point 1, they need to be a designer. Point 2, they need to have overall construction for pre-construction work so far as safety concerns. They need to have, the HSE says, knowledge relevant to the construction industry in relation to which this project relates. They need to have skills to manage and coordinate pre-construction works, and they need to have what is being defined as organisational capacity, which the HSE goes on to say will include setups within organisations such as appropriate health and safety policies, procedures, and skills in relation to risk assessment. And one of the issues for your business is going to potentially be also whether or not you might be that principal designer. We're going to pick up on this in our case study and look at the difference between designer and principal designer roles. But it may be that there's actually going to be an advantage to you as a business with this new definition of principal designer. As Alex has just discussed with client, we've prepared a table which compares the 2007 CDM coordinator roles and responsibilities with the 2015 principal designer role, if you turn to the next slide. And this slide, I think, really emphasises the difference, albeit subtle, between principal designer and CDM coordinator. What hopefully you can see from this is now the principal designer role is a very important role indeed on a project. The principal designer needs to plan, manage and monitor in the pre-construction phases. And whilst the CDM client is now going to always retain responsibilities that we've just spoken about, you will see that the principal designer has got a very big job to do, including coordination of the design team and ensuring that that design team is ensuring they're considering all safety issues in design work. They will be responsible for inputting on the timetable for works and also the order, thinking about the order in which works are going to be carried out and the relevance of safety. And as always, they're going to have to make sure that the principal contractor has been involved and got all the necessary information they have and they need to create their construction phase plan and essentially for the baton to be handed over in terms of managing safety once the construction phase starts.
Moving on to briefly look at the role of the principal contractor under the CDM 2015. Our view is that this is the role that has changed the least out of all of the roles with the change in the CDM regulations. As Mary has just mentioned, the principal contractor is in charge of coordinating health and safety during the construction phase, so takes that baton from the principal designer. The principal contractors have always been used to having these sort of overarching responsibilities during the construction phase, so that should be nothing new to them. The principal contractor must also prepare, review and update the construction phase plan. We will talk about that in a bit more detail as to what the construction phase plan involves shortly. However, it must emphasise that the construction phase plan must be done before the construction phase starts on site. The principal contractor must ensure that there are suitable welfare facilities on site throughout the construction phase, and that obligation is very similar to the obligation they had under CDM 2007. Principal contractors have historically complained about clients either not providing them with enough information or enough time to prepare the construction phase plan or to plan their activities appropriately. So the principal contractors should find that these changes should benefit them and ensure that they are able to comply with their obligations a bit easier. The increased responsibilities really focuses on the construction phase plan, which must be prepared for all projects and must be kept under review by the principal contractor throughout the project.
So in addition to the significant changes to principal designer role, the other, one of the other most talked about changes in 2015 is in relation to the definition of competency under the regulations. Under Regulation 8 of CDM 2015, competency is simply defined for designers and contractors as, quote, having skills and knowledge and experience to fulfill their roles, as well as organisational capacity, which we've talked about, meaning being able to demonstrate that they have the resource and policies and procedures to fulfill that role. Industry-specific guidance, which a number of employers had previously relied on to demonstrate competency under CDM, has now been removed. And so previous reliance on that is now gone, and it is now going to be for employers and CDM clients to determine for themselves what the criteria are that need to be met. Why is that? Well, there had been criticism, again, that the guidance was just leading to tick box culture, and that, in fact, a training course, just going on a training course, doesn't demonstrate competency, although it may be a way to measure competency. The only guidance that now really exists is that which we can see in the HSE guidance attached to the regulations, and that says that as a CDM client, you must take reasonable steps to satisfy yourself pre-appointment of necessary skills, knowledge and experience of those that you are appointing. The level of competency, of course, is going to depend on the project that's being carried out and its complexity. And turning to the next slide, the HSE guidance goes on to say that you need to ensure that those you are appointing understand the basic principles of health and safety and risk assessment. The level of understanding they need is going to depend on work, but as a CDM client, the guidance is that one should be looking at policies, procedures, resource and people in place. You could look at their experience, perhaps membership of professional bodies and track record. The main takeaway point here, I think, is that when making appointments as a CDM client, and this is probably equally going to apply when you are employing others, is that you need to determine those competency criteria yourself. You then need to assess against it, and this is probably something that your procurement teams will need to be considering, possibly in relation to questions in pre-qualification questionnaires and as part of tender process. The obligation is going to be on you to prove that those you are employing are competent, and there is going to be an emphasis on continual assessment and checks, so not simply relying on that first tender stage.
Looking at paperwork on the next slide, we've mentioned a couple of these pieces of paperwork already. To start with the pre-construction information, this is information which, as mentioned before, is in the client's possession or which the client can reasonably obtain. It must be relevant to the construction work and in an appropriate level of detail and proportionate to the level of risk. Now that can include information such as a pre-existing health and safety file for the original construction of a building. It can include site surveys, condition surveys, structural reports or information of that nature. And it must be information that relates to the project, its planning and management, and health and safety hazards associated with that project and how they might be addressed. And the client must provide the pre-construction information to every designer and contractor appointed on that project as soon as practicable, so as early as possible in the process. The second key piece of information, which we've already touched on, is the construction phase plan. This is now required on all projects, so not just the projects where there is more than one contractor or where the project is notifiable. If there is more than one contractor, it is the principal contractor's responsibility to prepare the construction phase plan, but otherwise it would just remain at the contractor's responsibility. The construction phase plan must include information that's, again, relevant, proportionate to the size and the complexity of the project. It should avoid things such as generic risk assessments and should take account of the pre-construction information, setting out the health and safety arrangements for the construction phase, site rules and similar matters. It also needs to respond to some specific risk areas. So the CDM 2015 sets out in Schedule 3 some specific risk areas such as assembly or dismantling of heavy prefab components or working near HV power lines, where the construction phase plan should specifically address the health and safety risks related to those issues. And finally, on the construction phase plan, it must be prepared before the construction phase begins, but must be reviewed and updated and revised during the construction phase to ensure that it remains applicable. The final piece of the paperwork jigsaw is the health and safety file, and this is only required where the project has more than one contractor. And it's the principal designer who is responsible for preparing the health and safety file. It contains relevant information regarding the project, which needs to be taken into account when the construction work is finished, and information such as risk registers, risk assessments, method statements, plans, etc. It must contain information on all the health and safety risks associated with the project and needs to be reviewed, updated and revised over the course of the project. As mentioned, it's prepared by the principal designer but is handed to the client at the end of the project. Looking at the key timings in relation to CDM 2015, we've already touched on some of these issues, but in terms of the appointment of the duty holders of the principal designer and principal contractor, these need to be appointed as soon as practicable, and in relation to the principal designer, before the construction phase begins, principal contractor before the construction phase begins, principal designer must be appointed before the design stage begins. If the appointments aren't made, the client must fulfil the duties that would otherwise be taken on by these duty holders. And there's specific arrangements for domestic clients. We've already touched on the paperwork requirements and the timing for that, the pre-construction information having to be provided early in the process, construction phase plan being needed before the start of the construction phase, and the health and safety file being developed during the course of the construction phase. Finally, notification, that should be done as early as possible in the process as well, as soon as the work is scheduled to meet the threshold. And then carrying on with the theme of notification, for those of you familiar with the 2007 regulations, and as I started this webinar with, you will be aware that notification used to not only be about when you had to tell the agency that you were carrying out a project, but it was also the trigger for you as a CDM client to put in place various appointments and paperwork. As I said, that part of notification is no longer relevant under the 2015 regulations. What is important about notification now? Well, as a CDM client, you still need to notify a project to the Health and Safety Executive on your F10 form when you anticipate that a project falls into the notification definition, or as Alex said, when it's scheduled to. It used to be that notification was the CDM coordinator's responsibility. Importantly now, it is the client's responsibility. As I said, it is still carried out on a similar form to previously, but one of the things that has changed is the threshold for notifying. The threshold's actually increased, so now fewer projects should need to be notified to the Health and Safety Executive. So when do you need to notify? If you were familiar with 2007, you'll be aware that you had to notify any project which was planned to be longer than 30 working days,
or exceeded 500 person days. That has now changed to projects which are taking longer than 30 working days and involve more than 20 workers working simultaneously on a project, or if you exceed the 500 person days. So moving on to the next slide, domestic clients. This is going to be relevant for the most part only if you are carrying out work at your own home. So we're giving this slide to our clients mainly just to give you background, but it may be relevant if you are part of the process on small domestic projects. Now, don't be worried if you are listening to this webinar and interested in this principally because you're about to plan a refurb on your own house. You're not about to be stuck with a lot of criminal obligations if you fail to meet CDM 2015. But who this is particularly relevant to is the domestic builder. Now, if appointments under CDM 2015 are not made on a domestic client project, it is going to be the contractor or the principal contractor who picks up the responsibilities. So if you are a domestic builder, then construction phase plans are going to have to always be prepared by you. Somebody is no doubt going to need to decide who the principal contractor is if there's going to be more than one contractor, and it's most likely going to be your responsibility to talk to your client about that. This is going to be equally of interest if you are a designer working on these types of projects. There does not have to be a principal designer on a domestic client project. However, there can be, and if you take on those roles, you will have the obligations that a principal designer does have. Also, as a designer, as we'll come to in our case study, you have obligations to ensure that your client is aware of their duties, and so that would come into play if you were filling that role. So before we move on to our case examples and pick up on a few application points of the new regulations, let's look at transition arrangements. And we anticipate that a number of you listening to this webinar will be listening post the 6th of April, and hopefully this won't come as a surprise. Essentially, what the 2015 regulations are providing for is a 6-month transition or buffer arrangement for certain projects only, though. And those transition arrangements are set out at Schedule 4 if you want to go and refer to the regulations. Who is going to benefit from the 6-month buffer zone? Well, if there is, immediately before the 6th of April, a project which is in its construction phase already, but there is no CDMC or principal contractor on the project, but more than one contractor. So the type of scenario we're probably likely to be talking about there are projects that previously fell under the old notifiable threshold, so there was no need to make appointments. Then on those projects, there will be no need to appoint a principal designer, but you must appoint a principal contractor on or shortly after the 6th of April. And then on or by the 6th of October, all the requirements of CDM 2015 are going to kick in. The second type of project which is going to benefit from the 6-month transition period is if you are pre-construction or construction phase and you've already got a CDM coordinator in place. And if you are in that scenario, you are going to benefit from the transition arrangements. But of course, where this project is likely to run past the 6th of October, you're again going to have to put in place all the arrangements. So you might want to think about doing that now if you're likely to run past. We wouldn't recommend leaving that right up until the last minute. Finally, if you have no CDM coordinator in place pre the 6th of April, and you are pre-construction, 6th of April, then you need to get a principal designer appointment in place. A word on paperwork and what is going to happen over the two periods. If you prepared your paperwork pre the 6th of April, then it can simply transition over and meet the 2015 obligations. Of course, your obligations, particularly as CDM client, but also other appointments in terms of making sure this paperwork is suitable and sufficient, is going to continue, so you will want to review that paperwork and make sure it does actually meet the requirements that either you had before or that you have now.
We're now going to look at two different case studies. Firstly, we're going to look at an example of an offshore wind farm business who has sites in the UK and Europe. And here we're going to look at who the client is and whether you can elect to have a specific party as client under CDM 2015, and we're also going to look at who the principal contractor might be. The first thing we should say here is that CDM 2015 applies to projects in Great Britain, the Territorial Sea or the Renewable Energy Zone. Now, helpfully, the Territorial Sea and Renewable Energy Zone should be defined terms included in the glossary to the guidance for the regulations, but the draft guidance unfortunately has omitted to define them. But for the purposes of this case study, we will assume that CDM 2015 applies to these sites. Those of you who are familiar with offshore wind farm projects will be aware that in many projects there will be more than one party potentially falling into the definition of a client under CDM 2015, as these projects often involve either a consortium of interested parties or more than one party, either working with another to develop the project, or more than one investor or funder in the project. And CDM 2015 says that there are certain things which need to be taken into account when determining who is the client. These include matters such as who in the chain has the ultimate decision on what is constructed, where it is constructed and by whom is the party who commissions or initiates the project, who sits at the top of the procurement chain, and who appoints the contractors. But you will appreciate that in this sort of scenario, more than one party could still well satisfy at least one of these criteria, so there could still be doubt as to who the client is. And those of you familiar with this under CDM 2007 will have been familiar with the fact that there is a concept of client election. So one party could elect to be the client for the purposes of the CDM 2007 regulations. Now, under CDM 2015, it is essentially the same. So the parties can decide in writing who is going to perform the role of the client for the purposes of CDM. And that client will be the one that then takes on the client obligations under CDM 2015. If no election is made, then all parties falling within the definition of client will take on these obligations. And election doesn't mean that the other parties who could be a client have no obligations under CDM 2015. They will still have the obligation to provide information for the pre-construction information and cooperate with others on the project. Now, turning to looking at who would be the principal contractor in this scenario, this can be tricky given that in an offshore wind scenario there's often a number of contractors and specialists working on the project at any one time. So each site or each wind farm is likely to be a project for purposes of 2015, but you could have different specialist contractors working on different parts of the site at the same time, or even the same part of the site at the same time. CDM 2015 does allow for more than one contractor and more than one principal contractor if there are two projects at the same site at the same time, but it suggests that this should not happen in the majority of cases. It should be a last resort, if you like, so that if there is more than one party potentially being the principal contractor, it should really only be appointing two principal contractors when there is no other option. It might be that you could break the wider project down into essentially smaller mini projects so that you have a principal contractor involved on each discrete part of the wider wind farm project at any one time. All of this should be borne in mind with the primary obligations of CDM 2015, that one party should have control over the construction phase to ensure that health and safety risks are mitigated. So that must be borne in mind when deciding how to structure this sort of project. Another consideration And another option for the client is if the client has sufficient in-house experience to do so, the client may be able to take on the role of principal contractor for the overall project and take on the obligations that that would involve. And if a client is considering doing that, then they need to make sure that they have the know-how, experience and capability to do this. And in that scenario, each of these individual contractors would then just be a contractor for the purposes of CDM 2015. Unfortunately, this is not something there's a one-size-fits-all, but it's something that must be considered very early on in the process to ensure that the structuring is appropriate and taking account of all health and safety risks.
Okay, well, we then move on to our second example, and in this example we're looking at a scenario where your business are contracted by a customer to supply, install and maintain industrial turbines on a premises. The customer in this scenario is going to be the CDM client, but there could be a question about the role that your business is going to play within CDM 2015, and of course whether it needs to fulfill any formal appointment role. One of the issues that the customer will be looking at as CDM client is how is it going to define the CDM project in the first place. Assuming that the installation of the turbine is a one-off installation with a continuing maintenance contract, it is possible that the CDM project will be the whole period from the first point at which the customer starts looking at options for turbine installation all the way through to the end of the turbine's life and its maintenance. Why do I say this? Well, if you look back at the definition of project under CDM, and that's something we haven't looked at in a huge amount of detail, you will note that it is intended to include all construction works, including planning, design management, and other work until the end of construction phase. Is the ongoing maintenance counted as construction phase? Well, we think that it is. Maintenance is specifically included as construction work under the definition we looked at, so it is presumed that this maintenance contract will still count as construction phase. So what does this mean for your business in this particular scenario? Well, that might depend on whether the CDM trigger for appointments has kicked in. So the test, as you're by now well familiar with, is whether there is more than one contractor. Here, is your business the only contractor involved? And are all the people working for you directly employed? If so, it may be that your business is simply going to have to pick up a contractor role, because that is the case. There's going to be no need for appointments. And of course, if that is the case, then you are still going to have to prepare your construction phase plan, because as Alex had indicated, that's now required on all projects. If, however, you determine, or the CDM client determines, that this project involves more than one contractor, as it seems very likely to do so in this scenario, the customer may come to you and ask for your business to be appointed as principal designer and principal contractor. And in terms of principal designer, that would be because of your specialist design skills and your ability to essentially project manage here. But also to be able to pick up during pre-construction phase, and then in terms of principal contractor onwards in terms of the actual installation, construction and maintenance. So that means that in theory you could be picking up both of these roles. What happens though if the customer decides that they will carry out the principal designer role in-house, or perhaps appoint somebody? Well, in that case, your business is probably here simply going to be designer and possibly also principal contractor. And we haven't talked a huge amount about what designer as opposed to principal designer role means under CDM and what your requirements are. What it does mean is that your business is going to have a duty to ensure that you've got the necessary skills and competencies to fulfill the role, which is doubtless going to be the case here as designer. And you are going to have a duty to cooperate with others, provide information to both the client and any principal designer that they have appointed. Additionally, and I touched upon this earlier in a domestic client situation, under Regulation 9, a designer has specific duties not to start work until they are satisfied that the CDM client understands their duties under CDM. And you are going to have duties as designer that when you are preparing designs that you take into account all health and safety issues to try and eliminate, or if you can't eliminate, at least reduce so far as reasonably practicable risk, including risks associated with ongoing installation work and maintenance work. So finally, an interesting point here on what happens if the design work is being carried out wholly or partially outside the UK. And that may often be a scenario with some specialist designs. Well, the HSE guidance on the regulations helps us a little here at paragraphs 77 and 78. And it says there that designer duties apply as soon as designs are prepared that are used in construction work in Great Britain, including concept design competition, bid for grants, and it goes on. So strictly, design work outside UK for construction work within the UK does fall within CDM 2015. Who takes the responsibilities? Well, the guidance goes on to say that if a design is prepared or modified outside Great Britain, then design duties apply to the person who commissions it, if they are established in Great Britain, or if not, the CDM client. So what this means likely in this scenario is that your business in the UK is going to pick up the responsibilities of the design, even where part of it is being carried out outside the UK. What is that going to mean practically for your business here? Well, it may be that you are going to want to take a greater interest in those very early stages of design, or to find out quite a lot more about how safety has been considered in the design work before you commission that work. So our final couple of slides. What do you as a business need to be thinking about following the 6th of April or in the immediate and short lead up that you might be in right now? Well, we anticipate that a number of you listening will have been very much involved in the thinking about this already. But the key pointers that we consider should be being looked at by all businesses are firstly, your health and safety project governance arrangements. What internal guidance is in place for your business, useful guidance to give a practical steer on CDM 2015? Is it in place? If not, prepare that. Secondly, who is going to be accountable for compliance within your business and how is that going to be managed? And because of this real emphasis going forward on focus at very early stages and proper appointments at an earlier stage than you might be used to, how is that going to work in your business in terms of the timings of contractual arrangements and planning, and how is that going to impact on resourcing internally? In terms of your procurement and contract strategy, we talked a little bit about setting criteria for competencies for projects and using those in pre-qualification questionnaires and part of tender processes. If that has not been done so already, we would recommend that your procurement teams and others look at that. In terms of responsibility and timing for appointments, as I've already referenced, how is that going to play out? And how are you going to structure your contracts? It will be wise to look at your contracts, and although in some circumstances there may only need to be minor amendments, there may need to be some changes in the way in which you structure your contractual arrangements. And finally, transition arrangements. Are you confident going forward that you know which projects are benefiting from the 6-month window and which are not? What's going to happen next? Well, a reminder of key dates here. The new regulations come in or have come in on the 6th of April 2015. At the moment, there is no approved code of practice from the HSE that gives you a practical steer, and as we've indicated, a number of industry-specific guidance documents have been removed. We will keep you updated if this changes, but it is likely that businesses are going to be a little on their own. How can we help at Osborne Clarke? Well, we are currently providing training for clients in-house, responding to queries, and working with legal and project teams on getting ready, and also following the 6th of April on carrying on to ensure compliance with 2015 CDM. At the very beginning of this webinar, there was an indication of our names, and if you turn to the final slides, you will see our lovely pictures and contact details for us. Please contact us if you would like to know more, or if you would like a flyer in more detail about how we can help your business. We would love to assist you. Thank you very much for your time, and have a good rest